good day students. My name is Isaac Okoli from Umgungundlovu TVET College, and I welcome you to today's session. Today we'll be looking at Public Law N6. And today the subject or the topic we'll be looking at will be the doctrines of law and the rule of law. And we just go straight ahead to look at the objectives for today's lessons. The first one is that we should be able to define and explain the doctrine of sovereignty, and also look at and explain the doctrine of the division of powers, as well as discuss the principle of the rule of law. So in other words, we'll be looking at three different concepts today. We should be able to define and explain the doctrine of sovereignty. We should also be able to explain the doctrine of the division of powers, as well as discussing the principle of the rule of law. Now, some previous knowledge should be assumed to be in place before we get into today's discussion. And that will be coming in now. We assume that we would have learned about the concepts of public law. These would be the definitions, the classifications of law, the public law, private law, and things like that. We should have also done a historical review of South African law, tracing the origins and that sort of thing. We should have also completed subjective laws, as well as the classifications of the various law courts in South Africa, and the legal functionaries and the various court officials. So these are the things or knowledge that should be in place before coming into today's session. All right, so we get down to the topic of the day, the doctrine of sovereignty. Before I start, I think it's important just to look briefly at the meaning of the word doctrine. Now, what does doctrine mean? It might sound a bit abstract, but doctrine is like a set of belief. It is something that we assume, it's a belief system that should be in place. It's almost like a practice that people go by. So that's the loose definition of the word doctrine. So today, the first doctrine that we'll be looking at is the doctrine of sovereignty. Now, again, it's also important that we understand the meaning of the word sovereignty. Now, it is derived, of course, from the word sovereign, and that means that it is the full right and power of a governing body over itself without any interference from outside sources or bodies. So that is the meaning of the word sovereign. It means you taking ownership of your choices and the decisions that you make without having to be dictated from external sources or outside forces. So again, that's a loose understanding of the meaning of the word sovereign or sovereignty in this case. So we continue now with sovereignty. In law, sovereignty is assumed to be an independent authority. Take note of the phrase there, independent authority, meaning not subject to any other power, internal or external. So it's an independent authority over a geographical area, for example, or in this case, a state. So when we talk about sovereignty in law, we are talking about sovereignty as it relates to a state, for example, the South African state. Okay, now it is also the highest authority in a state that is not subject to any other authority. Now, sovereignty was made popular by a French writer in the person of Jean Bodin, and he initially came up with the theory or the doctrine of sovereignty in the 16th century in a popular book that has come to be known as the Six Books of the Republic, or originally the sixth livre de République. Now, in it was the first time that the concept of sovereignty in the state was brought out or made public. And in this, he says, or he conceptualizes it as the absolute power of the state. Although initially he maintained that sovereignty was subject or is subject to natural law. But initially he conceptualized it as the absolute power of the state. Now, moving on, you see what we will notice from here henceforth is that it was initialized, or it was first popularized by Jean Bodin, but other writers and jurists after him started modifying and giving their own input of what they think sovereignty should mean. So after Bodin, another English jurist and philosopher, Thomas Hobbes, postulated that sovereign power is above everything, even religion. Now, this is a little bit of a variation from what Jean Bodin said. In this case, there's that consensus that there is sovereign power, but to him, it is even above religion, whereas Jean Bodin conceptualized it as within or only subject to natural law. So that was Thomas Hobbes. Now, after him came a German theorist and jurist and writer as well, Pufendorf, who came to the opinion that it is supreme in a state, but not absolute power. So what you begin to see is just the development of the theory or the doctrine or the concept of sovereignty. So, and then after him, if we go back to history, we also read about a popular French leader or ruler, that's Louis XIV. He used the concept of sovereignty to be free from the law. In other words, the state couldn't hold him responsible. His people couldn't hold him responsible because he made his rule to understand that he had absolute power. In other words, he was sovereign over the French Empire of the time and couldn't be held or called to account by the state or laws in that case. So moving on now, we also, I think this was in the 17th century, another Englishman, Thomas Smith, postulated that sovereignty belonged to Parliament, which is elected by the people, not the king or the queen. Now, this is, I think this still holds valid till this day. So he agrees, like the people before him, the theorists before him, that power should rest in a body and be independent to make laws. But however, he says that sovereignty, in this case, or the absolute power of a state, doesn't rest on the king or the queen of England. However, it rests with Parliament, and Parliament, as we know in most governments, is elected by the people. So this puts sovereign power in the hands of the people, according to Thomas Smith. And bringing it home now to South Africa, Parliament is assumed to be the highest legislative authority and is therefore assumed or known to be the institution that bears sovereignty or bears sovereign powers in the country. Parliament is only subject to the Constitution of South Africa. In other words, sovereignty in South Africa is not absolute. It rests with Parliament, but it is subject to the Constitution of the country. All right, so the discussion now is, what is the objective of the doctrine of sovereignty? You know, so the comment to make on this is that states should have some level of authority to make laws and also the authority to enforce them without influence or without interference from external factors or external powers, say other countries. So it's absolutely important that if a state has to exist, then it should exist on the condition that one of the conditions should be that it has sovereignty, it has the power to make its laws. So sovereignty is still a very relevant concept if a state has to have the power to govern. All right, so we move on now to the second doctrine that we will look at today, and it is the doctrine of division of powers. And it was made very popular, just like in the first one we looked at, by another French philosopher in the person of Montesquieu. And what is remarkable about the division of powers as postulated by Montesquieu is that it still holds valid. And by that I mean his exact words when he postulated, when he wrote about them, still holds very valid. So valid that I will read it verbatim. So according to Montesquieu, this is the foundation of the division of powers. He says that when the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. He continues, again, there is no liberty if the judiciary power be not separated from the legislative and executive. Were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would be then the legislator. Were it joined to the executive power, the judge might behave with violence and oppression. So, the offshoot of this is that the powers of a state should be separated, should be divided, and not concentrated on one arm of government or one authority of government. So that is the long and short of the division, the doctrine of the division of powers. So consequently, as a result of this doctrine, the implication of the doctrine then is that a three-sphere demarcation of state authority ensues. And that is, first of all, that the state should have a legislative authority tasked with the power to make laws. And then the executive authority of the state is given the mandate to carry out or to execute laws, or as some people say, to implement the laws. And finally, another arm of state authority has been identified, and that's the judicial authority, and that is to judge if laws were broken or if a law has been broken. So this is the offshoot or the implication of the doctrine of the division of powers, that the powers of a state be divided into three distinct and independent arms or hierarchies, if you like. Not hierarchies, rather, but spheres or levels of authority. Okay, all right. Then we look at the discussion then, coming from the division of powers. What is the implication, or what is the objective of the doctrine of the separation of powers? The simple aim or the simple objective of the doctrine of separation of powers is to ensure that the powers of a state are not concentrated on one element or one arm of government or only on one source of the state. Now, the reason for this is to ensure that power gets, possibly decentralized or spread, if you like. And the aim is to avoid the flagrant abuse of powers. According to Montesquieu, he says that if this happens in a case where one entity of government has all the powers of government, then there is a tendency for such entity of government to become, in his words, tyrannical. And that means to now use powers arbitrarily. I mean, in a manner that pleases him. It means this person or this arm of government would now choose when and when not to use or apply the laws of the land. So the division of powers ensures that the powers of the state are not concentrated. And basically, it's called checks and balances in simple terms. So one arm of government has powers, and those powers are used to check the other arm of government, ensuring that no one abuses powers. All right, we now move on to the third and last doctrine of law that we will be looking at today, and it is referred to as the rule of law. And this was made very popular in the writing of A.V. Dicey, another British jurist. A jurist is someone who's an expert in law, possibly through writings or even witnessing court cases and things like that. So what we notice is that quite a number of British and French writers and philosophers have made very considerable contributions towards the development of law in terms of writing and postulating about these doctrines. But anyway, moving on now, we go to the principles of the rule of law. And the basic principle is that the state may not execute its powers arbitrarily. Arbitrarily means as it chooses in a random manner. And then another principle of the rule of law is that individual liberty should be upheld. So the freedoms of individuals or citizens of a state should be respected and upheld. And then another principle is that everybody in the state is equal before the law. No person may be punished if the law of the state was not broken. And this breach of law, where it exists, must be established in a court of law. So it mustn't be random individuals who decide that a law has been broken. It should, in a democratic state now, or in a state that observes the principle of the rule of law, it should be that if I have broken the law, that must only be established in a court of law. So this is one of the main contributions of the principles of the rule of law. All right, we continue now. Nobody is also above the law, and everybody is ruled by the same law and through the same courts. We do not have courts for the middle class and courts for the upper class, so to speak. Everyone is served by the same courts. And the Constitution protects the rights and property of individuals and corporations. People are protected against arbitrary governance, dictatorship, and mob rule. Again, take note of the word, one common word there, and that is the word arbitrary, meaning random, meaning in a haphazard, in an unchecked manner. So people are protected from the random and flagrant use of powers by the state. And then, this one of the principles, again, it says that the rule of law aims to ensure a stable government. And then, in other words, a stable government will now ultimately lead to economic and social development of the society. All right. Now, we've spoken so much about the principles of the rule of law and the things that should be and the things that should not be, all the liberties that are guaranteed. Now, again, we talk about exceptions and limitations in emergency situations. And in other words, there are times when some of these liberties might be withheld. There are times when some of these liberties might have cause to be withdrawn, depending on the circumstance. So these are the limitations that we will look at. And now, what are the conditions for these limitations? First, if the danger is so bad that ordinary laws do not protect the citizens. If the danger is so bad that ordinary laws do not protect the citizens. Now, when such situations occur, then the state has the liberty or the freedom to now make extraordinary laws because there are emergency situations. And one practical example of that is the current state of most governments in the world as a result of the coronavirus pandemic. And that is, we find cases that where many governments have imposed some sort of restriction and regulation prohibiting the usual free movement of people. Now, ordinarily in democratic situations, ordinary situations, those things, those extreme measures wouldn't be taking place. But these are extraordinary circumstances. And that is why, if you guys have been paying attention to some of the addresses given by the president of the country, you would have heard about a state of disaster and so on and so forth. So it somehow can be likened to an emergency situation where, because it is an emergency situation, then the state now has the liberty to proclaim prohibitions, and these prohibitions are that you and I would stay at home and stay safe and things like that. Another principle or another condition will be that the action must be in proportion to the emergency. So in other words, the state has the liberty to impose restrictions on our normal rights. But when they do so, the action must be in proportion to the emergency. For example, nothing, this is just an example, a wild example, if you would excuse me, nothing would allow the state, for example, to take citizens without any cause and put them in prison without any good reason. So in other words, for example, like in the coronavirus age, what government has asked citizens to do is to stay at home. That is not very extreme, in the sense that somehow it is commensurate with the emergency situation. They haven't said you are given 24 hours to report to the nearest correctional facility. So this is an example of a situation where the action must be in proportion to the emergency situation. So finally, the question to ask is, how do these doctrines apply to South Africa? And by these doctrines, we mean the doctrine of sovereignty, the doctrine of the rule of law, and then the separation of powers. How do they apply to South Africa? Now, the application works to the extent that South Africa, being a democratic country, we know the history of that from 1994, has to observe democratic principles, and democratic principles operate through public law. So it is these principles that influence, or these three principles that motivate the kind of laws applicable in South Africa. So it is, if you think about the South African Constitution, you would see that it must have been influenced by the principle of the rule of law, which guarantees the dignity and fundamental rights of the citizens of a state. Now, if you also notice, South Africa also has three authorities of government, or three arms of government: legislative, headed by Mrs. Thandi Modise; the executive, headed by the president, Mr. Cyril Ramaphosa; and then the judiciary, headed by Chief Justice Mogoeng. Now, these are the three distinct, independent arms of government in South Africa, and they all work to check each other to ensure that one arm of government doesn't become too powerful, leading to abuses of rights. So these are fundamental principles which maybe before now we didn't know, but actually have been existing to influence and lead to how the government runs. So doing a quick recap now, we have now seen the three doctrines of law: the doctrine of sovereignty, the doctrine of the division of powers, and the doctrine of the rule of law. And we've seen the various principles surrounding them and how these principles influence public law. And we've also discussed the relevance of these principles to South Africa, or how they apply to South Africa. And I hope that you've come with me thus far, and that brings our lesson to an end. Till we see you again, stay safe and goodbye.